Welcome back to the channel and happy Friday. We're back in Lorchester with Mr. Swift, known to his friends as Speedy, who's worried that he's being caught by a speed camera on two occasions, one by a fixed camera, one by a manned speed trap on the side of the road. But first of all, if you're just joining our legal community and you've got questions of your own, don't forget to like, comment, subscribe and hit the bell icon so that you don't miss out on future videos. And just as a reminder, today I'm releasing a vlog over on Black Belt Secrets where I'm answering questions left by you guys in a slightly more relaxed format. So make sure you subscribe there and leave your comments for the next one. So Mr. Swift, in case you haven't gathered, drives around fairly fast and is frequently worried about getting caught by the fixed speed cameras or mobile speed cameras that you've seen either in the vans or handheld speed guns by police officers. Now, as you can imagine, there are thousands of people every single day that are caught speeding either by the fixed camera at the side of the road or by a police officer, either by standing with a radar gun or in a van. And when this happens, there's a whole process that's set off in the background, and most of this is automated. And within 14 days of being caught, you should receive through the post a notice of intended prosecution. The notice of intended prosecution should come out automatically to the address that the car is registered to. That's why it's very important to make sure that that address is kept up to date, otherwise you may not receive it. Along with the NIP, which it's known in short, should also be a section 172 notice requiring you to provide details of who was driving the car. The reason for this is that the cameras will ordinarily not capture a good enough photograph to show who was driving. And even if the photograph does indicate who is driving, you may still receive a section 172 notice requiring you and putting you under a duty to provide details of who was driving the vehicle at that time. They're allowed to require this information from you if you are alleged to be guilty of an offence, such as speeding. Now, Mr. Swift should take this letter very seriously because failing to respond to this letter is in itself a separate criminal offence, which could carry more points than his original speeding did in the first place. So he could get 6 points and a fine for failing to respond to this letter. Now, Mr. Swift is a bit concerned because he's not entirely sure whether it was him or his wife that was driving the vehicle at the time, because they do share the vehicle from time to time. But in response to the section 172 notice, Mr. Swift could nominate his wife or any other person that was driving the vehicle at the time. If Mr. Swift wasn't sure who was driving at the time, he's expected to exercise reasonable diligence to find out who it was. That's under subsection 4 of section 172. So what this means in practice is Mr. Swift should go back through his diary, find out what he was doing on that day, where he was on that day, where his wife was on that day if she sometimes uses the vehicle, and this is a duty upon him to exercise that reasonable diligence to find out who it was. Now, I must stress that it wouldn't be good enough for Mr. Swift to respond to say, "I just don't know who it was," thinking that he'll get away with it, without showing that he's done this reasonable diligence and still couldn't find out. In other words, if the response is, "Well, I genuinely don't know who was driving," Mr. Swift will be expected to show that he's done some reasonable diligence and he just cannot find out which of them that it was. I must also flag up a severe warning here, because in some cases, some people ask their spouse or some other person to take the blame for this speeding, perhaps because they've reached 9 points, and if they roll over to 12, they might have a totting up ban, meaning that they will be banned for a period of time. I'll discuss this in another video. But in this case, if this person is asking someone else to effectively take the blame and take any points that come with the speeding, this is perverting the course of justice, and the person doing so, or both people doing so, may well be prosecuted for perverting the course of justice. It goes without saying this is a far more serious offence than the original speeding was in the first place. So in the firmest possible advice, you must not nominate someone else if you know that it was you driving the car and you were speeding at the time. If you genuinely don't know who it was that was driving, but you have exercised reasonable diligence as to which of you it was, then you can respond to say that you don't know, but provide enough information to show that you've done this due diligence. If you're in the position where you've already responded, but you've sort of changed your mind about the situation, the police will very often allow you a second opportunity to correct that information before deciding to prosecute you. I should also say that you won't necessarily be going to court when you respond to this notice of intended prosecution, although the wording makes it sound very much like you're going to court because you've been caught speeding. But very often, if you respond to it and you tell the police that you were the one driving and you were the one speeding, very often the police will offer you a fixed penalty without going to court. If you're offered a fixed penalty, you'll usually have to pay a £100 fine with 3 points on your licence, although sometimes you'll be offered a speed awareness course instead. Perhaps if it's your first time speeding or you haven't been caught speeding for a long time. If you dispute that you were speeding, which you are entitled to do, you will have to go to the magistrate's court for a trial. Although you must remember that there's likely to be additional costs and a higher fine if you do challenge it in court and still lose. If you dispute that you were speeding, there is a time limit within which you can be prosecuted, which is 6 months. And this is held very strictly. In one such case, the evidence unfolded in court around a dispute as to whether the offence was committed before or after midnight. The result of it was that the information, that is, the information that must be laid before the magistrates to start the prosecution, was 1 day late, meaning the prosecution was out of time and the case was thrown out. But Mr. Swift shouldn't rely on this because in the vast majority of cases, the prosecution would be started well within time, or even if it's the week before the end of that time period, it will still be valid. You may have heard of lots of people that have had points added to their licence and their insurance premium gone up as a result, without even knowing about it. This usually comes about when your address hasn't been updated with the DVLA and all of the letters have gone to the wrong address and you knew nothing about it. And in that scenario, you've been convicted in your absence and you've had the points added to your license and you didn't even know about it. And you weren't given the opportunity to defend it or to nominate another driver if it wasn't you. In this case, Section 14 of the Magistrates Court Act 1980 allows you to make a statutory declaration to declare that you genuinely did not know about the proceedings against you and you didn't have the opportunity to make representations or to instruct a lawyer to make representations on your behalf. This effectively resets the conviction and allows you the opportunity to plead not guilty if you genuinely believe you weren't speeding or that it wasn't you in the car that was driving and speeding at the time. But obviously, if you get the details and you find out that it really was you, then there is no point in making this statutory declaration because it may still have been easier, cheaper, and less of an effect on you to accept those points and the fine in the first place. So just to reconfirm to Mr. Swift, the magistrates are very well aware that lots of people will say that they don't know who was driving, but they will be expected to show that they've done reasonable diligence to find out who it was that was driving. Simply saying I don't know without more simply won't be good enough. And simply ignoring the letter is not an option. It's a really bad idea because itself is a separate offence which can be much worse than the original speeding. And just a brief word on speed limits, although I will discuss it in a lot more detail in another video, so make sure you subscribe for that. But a lot of people think that there is a 10% plus 2 rule. One police officer on TikTok even said that it was built into legislation. This is not the case. It's not built into legislation. Speed limits are exactly as they sound. They are limits on speed. However, most police services do have a guide to which the police officers will work when looking at speeding offences. But it differs from county to county, so you should look those up depending on where you live. Most of those, broadly speaking, will have a tolerance, which is in lots of cases 10% plus 2 of the speed limit. But I, for one, would certainly not be relying on this, and I would stick to the speed limits. So thank you for joining us in Lorchester. No doubt there'll be lots of questions and comments which you can drop down below. I'll try to pick those up either in the comments or in another video, or perhaps over on Black Belt Secrets. In the meantime, don't forget to subscribe, and thanks for watching.